15, and to my left is the attorney extraordinaire, Benton Ross Watson. This segment is brought to you by Capulino Dodd Krebs Law Firm. Ross, tell everybody about Respect.
RespectForYou.com. It's Rick Dodd, Capulino Dodd and Krebs. Not criminal law we're talking about maybe a little today, but you got some problems with big corporations or somebody that hurts you, and you want to get some respect for you, call Rick.
It's a good connection there, the way they play that. Okay, so thanks, Rick, for the segment. And Ross, what we're going to talk about today, we're doing a series for the next 10 weeks. We're actually now this week and 8 to follow. We're about the Bill of Rights, and we're on number 2, the Second Amendment. And that's a big one with a lot of people, so we're going to discuss that. I got a couple of comments that I want to make on it. But I'll tell you what, ladies and gentlemen, I'm going to do this every week. I'm going to read the preamble to the Bill of Rights. And I'll say it again. When they ratified the Constitution, they wanted to make sure that certain things were not misunderstood. So the preamble to the Bill of Rights reads as follows. The conventions of a number of the states having at the time of their adopting the Constitution expressed a desire in order to prevent misconstruction or abuse of its powers that further declaratory and restrictive clauses should be added. And as extending the ground of public confidence in the government will best ensure the beneficent ends of its institutions. Okay? I think I screwed that word up. The Second Amendment reads, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And my first thing is going to be this. The word infringed. When you look it up in the definition, it's like it says don't jack with it. The other thing about the Second Amendment is the Second Amendment protects all the other ones. Without the Second Amendment, anybody can jack with the 1 through 9, mess with the Constitution, because there's nobody, the people, to make sure that government doesn't go rogue. Okay, so the Second Amendment is very important. And I'm sure you have a lot of things you want to go over on it as well. So why don't we start off with that? I
would definitely say, though, that my opinion is that every single one of the amendments are as important as the next one. And I said last week when we did our show on the First Amendment that if you go through us all the way through the Bill of Rights, through this series, that you'll see each and every single one of them, right, is intertwined and depends on the other one. Without your free speech and without your right to assemble, you couldn't associate and communicate with other people. Without the Fourth Amendment, you wouldn't be able to protect your personal liberty, your freedom of movement. Right? You wouldn't be able to protect your personal, private matters from government. Without the Second Amendment, you wouldn't be able to use force to protect these things. It would be, right, slaves of tyranny. There would be no way for us to fight back. You'll see from the Fifth Amendment, we could be railroaded. I mean, a lot of times you're already railroaded without these rights, and that shows the importance of them. Even all the times we talk about all the strange cases that come about, everything that the rights that we do have, but yet the system is still skewed. Think about if we didn't have these things.
Yep.
And so all of them are extremely important. And so, I mean, today we are talking about the Second Amendment. And
I want to make a comment though about what you just said. If you're a Game of Thrones enthusiast, there was one episode where Lord Baelish is talking to Queen Cersei, and he says to her, knowledge is power. And all of a sudden, she starts giving commands to her bodyguards to slice his throat, to hold him prisoner, so on and so forth. And she kept changing her mind in an instant. Every second she would change her mind, and they would just obey her, every word. And she goes, no, power is power.
Yeah.
And so when I say Second Amendment is the one that protects all the others, you have all these powers and the rights, the Bill of Rights, but this one's got the meat and potatoes to it that protects all the rest.
And so, as far as the muscle aspect is concerned, the Second Amendment definitely brings that to the table. And so, that's what really, though, is argued by the camp that says that the Second Amendment, right, doesn't protect our right to bear arms. They say that by stating that a well-regulated militia, as the beginning clause, as the clause that sort of introduces the amendment, that those opponents are going to say that this was only meant for, right, people in the military. This is only meant to protect the right of sort of state militias, sort of the Congress's right to, right, maneuver the militias, and that they could take that right away. And so that's where D.C. versus Heller came in with Scalia, and I'm going to talk about that today. But I wanted to start off with, you know,
Can I hold your thought for a second? I got to say this. You're reading this, and it makes me think of people when they look at it and they read the Second Amendment. Not that you did this. I'm just saying when you said something that made me think of this. People look at the Second Amendment as a bullet point. They say the militia. They don't do their history. They don't do their homework. And they don't realize that we, the citizens, are the militia. And you can see that in all different documentation throughout the history of this country, its formation, and all the letters and documents that the founding fathers wrote. You don't have to just read this per se. You can read all the supportive element as to how they came down to write it in the Second Amendment form. That we, the people, are the militia. At any moment, we can bear arms and we're ready to go.
That was actually a great introduction to what Scalia said in his opinion piece. So when he came into that decision, he said, remember I always talk about words mean things.
Absolutely.
Okay, and so when you talk about a grammatical genius, you're talking about Scalia in the vest. So some of this is way over our heads, but right of the people. So right of the people, they would not have used the people when we're talking about a militia in this context on the federal level. So when we're talking about the people, we're talking about the personal rights here. And so we're not talking about any one group, we're talking about the common. So if we're talking about the people, it's an individual right. And that's another thing, like you just said, infringed. I always talk about when we look at the Second Amendment, we know that right existed. And we talk about there's rights inherent, ordained by God. There's natural rights to man that the government had no right to take from you. It goes all the way back to Magna Carta. And so when we talk about those rights, right, it cannot be infringed. That means the right already exists. And so this amendment wasn't giving us anything. It was simply saying that the government can't come in and infringe that right that already exists. And so,
can I ask something?
Yeah.
If it says it can't be infringed, and that's in the Constitution, the Bill of Rights, okay, and anything not written in the Constitution, the Bill of Rights is left up to the states to determine. If it says in here it shall not be infringed, how can the state? Where does the state find that they can infringe upon us on how we carry? Who carries, what you can carry, and all that. How does that work?
So a lot of that is really hard for me to answer right now. I mean, this is really an area of developing law. Remember, we talked about United States versus Miller, and that goes back to like the 1930s. That was one of the first, Second Amendment cases. And remember, we spoke about it was kind of a set-up deal where it was a gangster that really never even contested it. He was just trying to get government help to get away from people who were trying to assassinate him, who eventually did assassinate him. And so it goes up to the Supreme Court level, and there's nobody even challenging on the other side. It's essentially like a default judgment. Like you are suing somebody, you hire Rick to sue you, somebody that hit you in a car wreck, and then you file a lawsuit, and they don't answer, and you show up, after 30 days, and you and the judge, and you get a default judgment. That's sort of what happened here. Was no contest, and so the court just sort of went along with the state's argument that okay, well, the Second Amendment doesn't apply, and it's not infringed by this Gun Control Act, and so that's how we got there. And then several years later, we have D.C. versus Heller come in and tell us, look, this is an individual right. It's protected by the Second Amendment. It was a natural right. It pre-existed right during the times of the founding. The founding respected this right. This right applies. Keep and bear arms has the same meaning back then as it does today, that we can carry arms. And it doesn't apply to a militia because the militia is made up by the people, and it only made sense that if you wanted to take away the militia, all you had to do was take away the people's firearms. And you had so many state constitutions with personal rights during this time say that there was for self-preservation, self-defense. You had several, including Texas's constitution, that included a right to carry and bear arms to protect yourself, to hunt, to protect your property. And these had nothing to do with the militia. And so they looked at all of those laws, and so we said that guns that were commonly equipped for military use were actually rights that were protected to the people. And so your question is a hard one, but we start off with, you wanted people during that time period to know how to use a weapon in case something were to, to use modern day terminology, pop off. Okay, if we were to get invaded and we needed to call a militia quick, you didn't want to have to train your populace how to use a weapon. They already knew how to use a weapon. They knew how to respect weapons. They knew what to do with it as soon as they were called to duty. Mm-hmm. And they were not scared to be called to duty because they were well trained, because they always had these on them and they always trained. And so those things were military weapons during that time period. And so today, the tough question is to strike a proper balance. Do we want people walking around with bazookas, 50 cals? Probably not, but at the same time, do we want responsible people trained to use those and able to use those in a safe way that we're sure of? Is that permissible? And so I would say yes.
Let me make a comment on the bazooka thing. I know Rick brings us up to a nuclear bomb and all this kind of stuff. Use the First Amendment to prevent that from happening. And let me tell you what I mean. If you got somebody carrying a bazooka for self-defense, he's going to be shamed, or she's going to be shamed by all the other reasonable people saying, man, you idiot, what the heck you carrying a bazooka for? And he's going to get to the point where it's no fun. He's not cool. He's not hip, because he probably is a loser to begin with because he's got to carry a bazooka. You know, it's like if you're a guy and you get a Corvette, what people say about you, you're using the Corvette to make up for...
Yeah.
Well, so he's got a bazooka because he's trying to make up for some,
you got to realize there are dangerous people out there, and there are people that are going to try to hurt us, not just to be cool, not just to fit in. Maybe they want to get their message across in a dangerous way. To do it, maybe it's just for attention. But regardless, there are some people that the state feels they have a right to regulate to some degree. Felons, which we've already talked about to some degree. That's it's a little absurd in some cases, but in other cases, it's well deserved. And right, the democracy, the republic that we have, is not perfect, and so we have to try to strike some sort of middle ground compromise about what we can regulate and what we can't. And we're getting into these cases. So then we had McDonald versus Chicago. That was a 2010 after Heller came in, and it was basically Chicago trying to prevent everybody from owning a handgun. And we now know from that case that the Second Amendment does apply to the states. Okay, and it's sort of complicated. Originally, the Bill of Rights were said not to apply to the states. It was just a federal thing. It only prevented the federal government from coming in and doing something. The states already had their own rights, and it was understood that they were separate. And during that time period, a lot more rights were given on the state level than they were on the federal level anyway. Okay, aside, from the bad things, slavery and such. But from just a general standpoint, a lot of times the state rights gave more, and they still give more to some degree. But that case talked about incorporation, and after the Civil War, we had the 14th Amendment. And when we had the 14th Amendment come about, that incorporated all the Bill of Rights, okay, to control state level operations. Not every single one of them. And remember, there's clauses within the Bill of Rights. Each amendment has its own separate clauses, and so some clauses were said to apply, some were said to not to apply. But here, we have the Second Amendment now being incorporated either by the Privileges and Immunities Clause within the 14th Amendment or the Due Process Clause. Regardless, we know that it's incorporated and applies on the state level. And so, because it applies on the state level, the state could not come in. And remember, D.C., Columbia, right, was not necessarily a state. Okay? It was its own little nation, its own little independent body. Okay, and so this case was important because it applied on the state level to prevent Chicago from the municipality from regulating the Second Amendment rights. So now we know that we have this right. And now the question is, right, what does it apply to? Well, we have several cases of Fifth Circuit opinion talking about felons possessing firearms. They upheld the laws outlawing that. It was not unconstitutional. But then in 2016, we had Caetano versus Massachusetts. It was about a stun gun. And it's a very good case. And so what happened here is that the state of Massachusetts outlawed stun guns and made it a crime essentially to have that type of weapon. And Miss Caetano, right, was caught with one of these weapons when she was in her purse. when she was talking to police officers about another case, they saw the stun gun in her purse and they ended up arresting her and convicting her. Well, they ended up going all the way to the United States Supreme Court. And really, it's not even that long of opinion, and it's a great read. It's short and it's aggressive. It's my kind of style of case that I like to read. And they went real quick at the beginning, and I'm going to read some of Justice Alito's concurring opinion. But they talked about, they first said that stun guns are not legal. This is the lower courts in Massachusetts, said they weren't legal because they were not in common use at the time the Second Amendment's enactment. And if you remember, see, I'm kind of getting your question, but your question is very broad, okay? Justice Scalia said that we don't apply constitutional amendments, right, in a vacuum that was back in the 1700s. We apply it, not necessarily, he didn't believe in necessarily an evolving constitution either, but we've got to apply it to the everyday, right, sort of circumstance. Okay, and so
what was common back then was common.
Was muskets. Today,
it's
common is handguns, absolutely. And so in the Heller case, he said this very common. Most Americans do have the handguns. It's essential for home defense use. This is what the fundamentals of the Second Amendment were made to protect. Right? We cannot come in and infringe on that right. And so that was the right. Even though handguns weren't there at the time the Second Amendment was enacted, it's a common use. Mm-hmm. Okay, and so they said that's absurd to say that because stun guns weren't in use at the time the Second Amendment was enacted that it's illegal. That's absurd. And then the lower courts said that.
Hold on a second, ladies and gentlemen. This is very interesting. While he's reading, the number here at the studio is 254-697-6633. I'm sure somebody's got a question. Go ahead.
And then the lower courts in Massachusetts also said that they were illegal because, and it was constitutional because the guns were unusual because they were a thoroughly modern invention. Well, the Supreme Court said that's the same thing. That's the exact same thing as what we just said. Just because it's not in use at the time of the Second Amendment doesn't mean that it's not common. To say that it's a new invention would be to say that it was not in use at the time of the Second Amendment. Therefore, since it's now common today as an invention, we can't use it. They said, no, we're not going to go with that. And then I talked about, well, a stun gun is different from what Scalia said because it's not readily adaptable to military use. And we don't only look at the weapons that were adaptable for military use. There are other things other than a militia. We're not only concerned with the militia. We're concerned with personal preservation, protection of your home, protection of your family, protection of your property, to go hunting, to go in sporting events. We are also concerned in personal liberty. Okay, and so these things, right, were ridiculous to say that it was constitutional to outlaw stun guns. And there was evidence presented before the court, and this, I thought you would really like this opinion because you're always talking about the club. Remember, you always bring up the clubs. Mm-hmm. And so I think that eventually some of the Texas laws on the books are going to be called into question because of this Caetano case. But
what causes a law to be in question? Somebody gets arrested and wants to fight it?
Exactly. So Miss Caetano got convicted for having this stun gun. Mm-hmm. And here's what Alito says. After a bad he starts the opinion like this. It's beautiful. After a bad altercation with an abusive boyfriend put her in the hospital, Jamie Caetano found herself homeless in fear of her life. She obtained multiple restraining orders against her abuser, but they proved futile. So when a friend offered her a stun gun for self-defense against her former boyfriend, Caetano accepted the weapon. It is a good thing she did. One night after leaving work, Caetano found her ex-boyfriend waiting for her outside. He started screaming that she was not going to expletive work at this place anymore because she should be at home with her kids they had together. Caetano's abuser towered over her by nearly a foot and outweighed her by close to 100 pounds. She didn't need physical strength to protect herself. She stood her ground, displayed the stun gun, and announced, "I'm not going to take this anymore. I don't want to have to use the stun gun on you, but if you don't leave me alone, I'm going to have to." The gambit worked. The ex-boyfriend got scared and left her alone. It is settled that the Second Amendment protects an individual right to keep and bear arms that applies against the federal government and the states. That right vindicates the basic rights of individual self-defense. Caetano's encounter with her violent ex-boyfriend illustrates the connection between those fundamental rights. By arming herself, Caetano was able to protect against physical threat that restraining orders had proved useless to prevent. And commendably, she did so by using a weapon that posed little, if any, danger of permanently harming either herself or the father of her children. Under Massachusetts law, however, Caetano's mere possession of the gun that may have saved her life actually made her a criminal. When police later discovered the weapon, she was arrested, tried, convicted. Massachusetts Supreme Court affirmed the conviction, holding that the stun gun is not the type of weapon that is eligible for Second Amendment protection because it was not in common use at the time of the Second Amendment's enactment. This reasoning defies our decision in Heller, which rejected such arguments as frivolous. Not that only those arms in existence at the 18th century are protected by the Second Amendment. The decision below also does a grave disservice to vulnerable individuals like Caetano who must defend themselves because the state will not.
Couldn't have said it better myself.
Man, he goes on there, but I won't read it all. But man, he really comes out with fire in that opinion, and I think he hits the very heart of the issue. And it's like you said, when we talk about the girls, and I'm not being sexist, but when I think about my boss when she goes running, right? I want her to be able to carry something like that in case something happens, and it's not always feasible to carry a firearm on you in situations like that. And I know you have some gadgets and gizmos, but still, sometimes those types of devices are a whole lot even more safe because she can hold it in one hand. It's right here, ready to go if something ever happens, right on the spot. And
I don't care what it is, as long as it does the job. You know?
Exactly. And so I think that you just kind of answers your question, right? What kind of weapons, when is this state regulation, when can they regulate and when can they not, and why can they regulate and why can't they? Who would have thought that the Second Amendment, just 10 years ago would have included stun guns? I agree with the opinion, absolutely, because the fundamental right is the exact same. It is the fundamental right that they're protecting, not the object. They're not protecting the weapon. They're protecting the right. And so I believe that the opinion does the Second Amendment justice, and I believe it hits it right nail on the head. But how far, what specific weapons are they going to accept as being protected by the Constitution? Time's just going to have to tell. And with here, remember they have evidence that many people are trying to use these types of devices, and so that was presented to the Supreme Court, and they considered that, and I think that did play a role. And a lot of this statistics are done by the NRA, so I mean that's what that organization gives you.
I'm silent because I have so many questions running through my head. I don't know what to ask. It's just you can go in so many different directions with this. And I think what I want to run away with is that people need to just not read at face value what the Second Amendment means. You got to learn its history. You got to understand it, like you're explaining here. And once you have a better understanding, you see how it applies better and how much more you want to protect it. People get very misguided when they see militia, and they have to have an understanding of it. And there's other rights that we're going to be going over as time goes by that I'm sure other people will not truly understand until we explain it. But I mean, explaining it in this manner opens up to a lot of people that there's still a lot of confusion, and we have to be very careful on how we handle ourselves.
Well, so Scalia pointed out in his Heller opinion that we have just time after time again when emperors or kings or totalitarianism regimes wanted to control the people, they didn't always disband the militia. They just disarmed them and disarmed the people. And so a well-regulated militia being necessary to the security of a free state is absolutely true, because we want, like we said, we wanted our people to understand, be trained, be armed, be ready, be able to defend themselves in an instant when tyranny was on our doorstep.
I was just going to bring that up. We keep talking about self-defense, but one of the main reasons for us to bear arms is in case we have a rogue government. We're supposedly be able to protect our government from people inside it becoming rogue. How are you going to do that with a musket? You've got to maintain modern arms to what your government authority has. Otherwise, it's going to be a bloodbath.
Correct. And so you'll see on TV and a lot of internet websites, they say that based on that opinion, I don't know what they're reading, that based on that opinion, you can't have modern day weaponry. Well, that's not at all what they said, obviously, because they just said it doesn't depend on whether it existed at the time of the Second Amendment's enactment. Yes, it talked about there being very extreme, high-tech military weapons that obviously we're not going to give right to society. I don't even think you would argue with a lot of those weapons that we're talking about, but at some level there's got to be a compromise. But we're definitely not saying that no advancements in weaponry can be made. Remember, we're not protecting the weaponry. We're protecting the right.
I concur. There's, I don't know, there's, if you look at it, if the government doesn't like a certain sector, they're going to put a drone strike on you. So an AR-15 and semi-auto mode is not going to do a damn very good anyway.
Correct, and then correct. It's just, I mean, obviously the drones is another thing, but if people are resilient, if something did happen, I'm sure people would find a way to take them down. And it was, if we didn't have any, we would sure be more vulnerable than if we do.
Well, it's like I wrote my opinion piece. The reason they want to take them away, the basic agenda for taking away the gun is to prevent resistance from those who disagree with those in charge. So if you got a group that's in charge and they want to take away your guns and say, well, we got it, they can't really resist us, we're going to do what we want to do.
So all right. Sometimes you get a good old mentor of mine used to say, sometimes you just got to make them come to their milk. And I mean, sometimes even if you're fighting a losing battle, sometimes the fight is what counts.
That's right, because you never know what can happen. It can always change. All right, let's finish it up. Tell everybody who you are, where they get a hold of you, and we'll take it from there.
Benton Watson Legal PC 254-605-4140. That's 254-605-4140. That's my phone number. Give me a call if you have any questions about the show, or if maybe we just briefly touched on something or was about to get to something that maybe you thought and wanted to ask a question about it. Please send emails. We're getting a lot of emails. I do appreciate them. Make sure you leave your phone number so I can give you a call in case I can't get back to you on email. And my email is benton@watson.legal. That's benton@watson.legal. Or come see me at the office here, 105 East Main Street, here in Cameron. Big Milk Homicide. You can't miss it.
Sounds good. Rick, we appreciate Copeland & Dodd Krebs Law Firm for sponsoring this long segment.